On January 28, 2026, a Supreme Court decision sent shockwaves across the globe. The world watched as the highest court in the United States prepared to deliver a verdict that would ripple far beyond the marble steps of its iconic building. The air was thick with anticipation, as legal experts, tech leaders, and ordinary citizens alike waited to see how the future would be shaped by the words spoken within those hallowed halls. The 9 justices, each with their own philosophies and life experiences, handed down a ruling that would reshape the very fabric of our digital existence. Their decision was not just a matter of law, but a reflection of the values and fears of an entire generation grappling with the rapid evolution of technology. This was more than a legal judgment, it was a declaration about the future of privacy, technology, and personal freedom. Outside the courthouse, protesters waved signs demanding digital rights, while inside, the gavel's echo signaled a turning point in the ongoing battle between innovation and individual liberty. The case, Innovate Forward vs. United States, became the vessel for a monumental question: how much of our digital selves belongs to us, and how much can the government access? The arguments presented were complex, touching on everything from encrypted messages to cloud storage and the very nature of what it means to be private in a connected world. News alerts lit up from London to Tokyo as the decision was announced. Journalists scrambled to interpret the ruling, translating its impact for audiences in every corner of the globe. Headlines flashed in dozens of languages, each one underscoring the universal importance of the court's words. In our interconnected age, American technology and laws set a global standard. The influence of this decision would not be confined to U.S. borders. It would shape the policies of governments, the strategies of corporations, and the daily lives of billions. The rules governing data on servers in Virginia or California impact users and businesses worldwide. Every email sent, every photo stored, every transaction processed, these digital footprints are subject to the laws set forth in this moment, affecting people from São Paulo to Seoul. The court was not just interpreting an old law, it was setting a precedent for a new frontier. Their deliberations would become the foundation for future debates about artificial intelligence, surveillance, and the boundaries of personal autonomy in the digital era. The implications of their decision will unfold for years, affecting how we communicate, do business, and define privacy in the 21st century. From remote work to online banking, from social media to medical records, every aspect of our digital lives will be touched by this landmark ruling. This is the story of how, for a brief moment, the digital world stood still, holding its breath as the future of privacy and freedom was decided in a single, historic stroke of the gavel. To grasp the gravity of this moment, we must understand the Supreme Court's challenge, applying the 18th century Constitution to 21st century technology. The Fourth Amendment, protecting against unreasonable searches, was written for a world of physical papers and homes. But what happens when your papers are emails and photos stored on distant servers? Lower courts clashed over whether data given to tech companies deserved less protection, citing the outdated third-party doctrine. Privacy advocates argued that using technology is now a necessity, not a choice. Tech companies were caught between user privacy and government demands, while law enforcement warned that warrant requirements could slow investigations. The stage was set for a major Supreme Court showdown. At the heart of this landmark case was Innovate Forward, a rising star in the tech world known for its unwavering commitment to user privacy and cutting-edge encryption technology. The company had built its reputation on the promise that users' data would remain secure, private, and inaccessible to anyone but the rightful owner. But in 2023, everything changed. A powerful federal agency issued a sweeping demand. They wanted unrestricted access to all data stored on one of Innovate Forward's main servers. Data belonging to thousands of users, the vast majority of whom had no connection to any criminal investigation. Innovate Forward refused to comply, arguing that such a demand amounted to an unreasonable search and a clear violation of users' Fourth Amendment rights, which protect against unwarranted government intrusion. Our users do not surrender their constitutional rights when they store data with us, declared CEO Anya Sharma, standing firm in the face of mounting government pressure and public scrutiny. The legal battle escalated rapidly. The district court initially sided with the government, ruling that national security concerns outweighed privacy. But Innovate Forward appealed, and the appellate court reversed the decision, emphasizing the fundamental importance of digital privacy and creating a legal split that only the Supreme Court could resolve. The Department of Justice responded forcefully, warning that the appeals court's decision could severely hamper critical investigations and set a dangerous precedent for law enforcement. In early 2025, the Supreme Court agreed to hear the case, recognizing its profound implications for the future of privacy and government power in the digital age. The stage was set for a historic showdown. The final battle for digital privacy was about to begin, with both sides preparing for a fight that would shape the rights of millions. The world watched with bated breath as the stakes grew higher and the outcome became more uncertain. Innovate Forward versus United States would ultimately decide not just the fate of one company, but the very future of digital privacy for everyone. On January 28, 2026, the Supreme Court sided with Innovate Forward in a 6-3 decision. The ruling declared that the government's demand for bulk data was an unconstitutional search under the Fourth Amendment. The majority affirmed, digital privacy is not a lesser form of privacy. People retain a reasonable expectation of privacy in their digital files, even when stored with third-party companies. The decision modernized the Fourth Amendment, extending its protections to the virtual world. The government must now obtain a specific probable cause warrant for digital content. Broad sweeping data demands are unconstitutional. This landmark ruling set a new standard for privacy in the digital age. The majority opinion, authored by the Chief Justice, affirmed that rights must evolve with technology. The court rejected the idea that storing data in the cloud meant abandoning privacy. A cloud server, they said, is like a safe deposit box, entrusted, not surrendered. A person does not lose their expectation of privacy in their digital life simply by using modern tools, the opinion stated. The ruling drew a line. Content like emails and photos is protected. Metadata may be addressed in future cases. The court was unequivocal. A specific justified warrant is required for digital content. As our lives move online, the potential for government overreach grows. This decision is a necessary check. The ruling sets a durable standard for privacy in a rapidly changing technological landscape. The three dissenting justices issued a stark warning. They argued the majority's decision would create major obstacles for law enforcement, endangering public safety. Digital evidence can vanish or cross borders instantly, requiring specific warrants for every piece of data, they said, is unworkable. The dissent claimed the court was applying analog rules to digital problems, prioritizing privacy over security. They insisted Congress, not the judiciary, should craft digital surveillance laws. The dissent warned of an arms race, criminals exploiting new rules, law enforcement seeking workarounds or broader powers. The ruling, they cautioned, could lead to either less security or more intrusive surveillance. The debate over privacy and security is far from over. The dissent's concerns will shape the next chapter. This decision has immediate consequences for anyone using digital technology. Your emails, photos, and documents stored with tech companies now have stronger legal protection. Government agencies must get a specific warrant to access your digital content. For tech companies, this ruling is a global selling point, especially in regions with strict privacy laws. Innovate Forward's CEO called it a victory for our users and for the future of a free and open internet. The decision redraws the boundaries of private and public life, fostering greater freedom and security online. Activists, journalists, and minority groups gain crucial protection from warrantless surveillance. Law enforcement faces new hurdles, and the debate over privacy versus security will intensify. The real-world effects of this decision are only beginning to unfold. For a deeper long-term perspective on this landmark case, we turn to Dr. Evelyn Reed, a leading legal scholar at the Stanford Center for Internet and Society. Dr. Reed has spent years studying the intersection of law, technology, and civil liberties, making her uniquely qualified to interpret the broader implications of the Innovate Forward decision. She described the Innovate Forward decision as nothing less than a fundamental reset, a pivotal moment that redefines the relationship between citizens, the state, and the rapidly evolving world of technology. According to Dr. Reed, this ruling marks a turning point in how our legal system views digital privacy. The court decisively moved beyond the outdated focus on the physical location of data storage. Instead, it recognized that digital files, whether stored on a personal device or in the cloud, are as private and sensitive as handwritten diaries or sealed letters. This shift acknowledges the deeply personal nature of our digital lives. The majority's opinion was carefully crafted to be technologically neutral, ensuring that its principles will remain relevant and adaptable as technology continues to evolve. This approach prevents the law from becoming obsolete as new forms of communication and storage emerge. Whether our data is stored on today's cloud servers, on tomorrow's decentralized networks, or on devices we haven't yet imagined, the core principle remains unchanged. Privacy protection is paramount. The court's decision sets a clear standard that transcends specific technologies. Dr. Reed acknowledged the concerns raised by the dissenting justices, who worried about the potential impact on law enforcement. However, she offered important context. The Fourth Amendment was always intended to make government investigations more difficult, not easier, in order to safeguard individual liberty. The requirement for a warrant is not a bureaucratic obstacle, but a deliberate and essential safeguard. It is designed to serve as a check on government power, ensuring that privacy is not sacrificed in the name of convenience. This decision does not prevent legitimate investigations from taking place. Instead, it demands that authorities respect individual privacy and follow constitutional procedures, reinforcing the balance between security and freedom. Ultimately, the ruling empowers citizens, giving them greater confidence in their digital interactions. It sets a forward-looking standard for digital rights, ensuring that privacy remains a core American value in the digital age. With this decision, the digital age now has a strong constitutional foundation for privacy, one that will guide and protect future generations as technology continues to advance. The Supreme Court's decision has drawn a new line in the sand for digital privacy. But this is just the beginning of a new chapter in the national conversation. Law enforcement and security agencies will push for new legislation to regain investigative powers. This will spark a major debate in Congress about the balance between privacy and security. As citizens, our voices matter in shaping these laws and holding companies accountable for our data. The decision empowers consumers to demand more from tech companies and use privacy tools. Our constitutional rights must be defended and adapted for each new era. The principles of freedom and privacy are not relics, they are essential values for the digital age. The road ahead is uncertain, but we now walk it with a clearer understanding of our rights. The story of Innovate Forward versus United States is just the beginning of shaping our digital future.